everyone to joint rules and regulations. I'm sorry to be late. Just a little bit of technical difficulties by the chair. I think what we're going to do is wait to approve this last meeting minutes until we have more people inside the building. Does anyone have a problem with that? Seeing none, we can go ahead and get started. We're going to start with the Department of Agriculture, Division of Conservation. And I'll look to see who's coming here. He's here in person.
Good afternoon, Madam Chair, members of the committee. My name is Kenny Titus. I serve as Chief Counsel for the Kansas Department of Agriculture. We're bringing before you today Administrative Regulation 11-9-5. This deals with the Kansas Water Quality Buffer Initiative. It is authorized by KSA 2-1915. This program was developed as a complement to the Federal Conservation Reserve Program, or CRP program, and it provides state matching funds to otherwise eligible projects. The way the current regulations were developed some years ago, they called for payment to mirror the federal payment system. So over the life of, say, a 10-year project, and they can go up to 15 years, every year the federal payment would be made, the state match would be made on behalf of that. But we found that in some cases, dividing the state match by 10 years results in a very small payment. So when we went through our data, there were some people receiving a $3 check from the state every year for 10 years, which requires us to follow through with all of the paperwork time and things like that. But it just doesn't seem very practical. So when we've done a comprehensive look through at our files, our Division of Conservation staff would like to be able to make a lump sum payment to finish out some of these contracts that are still on the books for small amounts. But the way we had written 11-9-5 originally, it did not allow, it was written specifically to require the annual payment. So we've added the language in subsection E that would allow, at our discretion, a lump sum payment if it made sense. So I'd be happy to answer any questions on that.
Thank you very much. Does anyone have any questions? Representative Carmichael. Did you hear me, Representative Carmichael?
I did. I apologize. I was trying to find the right button on my console on my computer. I apologize. Mr. Titus, I just wanted you to know that I appreciate the economic impact statement that you prepared on this. It was easy to read. I could understand it. And even though this is not a particularly significant matter in terms of costs, I appreciate the agency's time in complying with the law and preparing the statement. Thank you, sir. Thank you, Madam Chair.
Thank you, Representative. Are there any other questions or comments? Representative Webb.
Yes, so I'm looking at the, you have fiscal year 2021, 627 remaining state incentive contracts, $82,000. That's about $132, per contract. I guess I can track what you guys are thinking about for really low level amounts, but if it's a couple $100 a year, you would still want to consolidate it, or do you have a economic benchmark, or it's just at your discretion? I think it says at your discretion, but.
So funding is provided through the state water plan each year to pay off these contracts, and that'll vary from year to year, and depending on the level of projects that are being used. So the idea would be to pay off as many of these as we can, as quickly as possible. So they're still subject to the terms of the contract. They're still getting the much larger federal payment for the remainder of the terms, but for fiscal year 21, assuming everything passed, we have, with carryover from last year, there's roughly $530,000 of funding available for this program to be used in fiscal year 21. That would actually pay off about 500 of the 627 contracts, and then we would work on the last 127 as funding was available.
If I may ask, so you would literally pay off every single contract, regardless of how big it is, is your desire with this regulation?
I would have to, we have some program staff, if the chair would like them to answer that. I don't know if there's a threshold where they would hold that contract longer. I'd have to defer if that would be okay.
Absolutely. Were there any other questions?
We have Mr. Frost, if he is on WebEx, he can answer that question. Steve, if you want to introduce yourself.
It's a very good question. I think the intent is actually to pay as many of the contracts as we can possibly afford with the funding that's provided through the water plan, as Mr. Titus described. One of the problems with the contracts that wasn't foreseen in the beginning development of the program is that not only are some of these very small acreages and then very small incentive payments, but sometimes there are multiple landowners, and every year we experience a number of landowner changes due to sales, estates, or deaths, or a number of different things. And it becomes extremely complicated trying to track down all of the new ownerships, get new social security numbers, and get all of those things in place. This program has been running for over 20 years, and I think it's really done most of the work that it was intended to do. There's been a new program that replaces this one. It's much more flexible. It adds additional practices, and it also provides just a one-time upfront incentive payment instead of the reoccurring one that Mr. Titus described. So again, the intent would be to try and eliminate as much of that administrative burden as we possibly can, because we've already started a new program. We're not accepting contracts under this one anymore. The intent is just to close this one out as quickly as possible.
Thank you, Mr. Frost. I have a couple of questions, unless someone else has one that they would like to. Or, what's the name of the new program is my first question.
It is the Kansas Sediment and Nutrition Reduction Initiative.
Mouthful. Would you be able to send us information on that new program in case
Absolutely.
we get constituent calls? And also my other question was, what was the feedback that you got from the Kansas League of Municipalities and the counties?
We didn't have any feedback from those organizations. We did send them the normal notice, but didn't have any response from them.
Okay. Thank you. Any other questions? Thank you very much for joining us. I appreciate that. Our next conferee will be from the State Board of Healing Arts.
Madam Chair, members of the committee, my name is Tucker Poling. I'm the Executive Director of the Kansas State Board of Healing Arts. I'm here to provide the committee an opportunity for review and comment pursuant to 77-436 on two pending regulations that we have. One is 115-4, the other is 115-5. These two regulations, what they do, the updates to these regulations, what they do is it would require physicians to have at least an hour of continuing medical education on specifically opioid prescribing, pain management topics. And this was as a result of the opioid advisory task force that was created by Governor Collier a few years ago. One of the recommendations was that we add a requirement that at least some of the continuing education hours that we require be in the subject matter areas of appropriate standards of care relating to pain management, opioid prescribing, and the use of the prescription drug monitoring program. And I'm here for any questions the committee may have or comments.
I see Representative Carmichael has a question.
Thank you, Madam Chair. Mr. Poling, can you explain to me how the agency consulted and solicited information from businesses, associations, local governments, state agencies, or institutions and members of the public that may be affected by the proposed rules and regulations?
Well, these were first developed in discussions at open board meetings in 2018 and as a topic of the discussion at the Opioid Advisory Task Force, which does involve a lot of those types of organizations. We routinely send these out to, notices of what we're doing, the proposed regulations, to the various professional organizations. So that's what we've done thus far.
So can you explain to me why it is in subsection 3H of your economic impact statement that you did not describe any of that to us so that we would know that you had done those things? Because your economic impact statement, as I read it, says that you just noticed up your regular meetings like you always do, and we were supposed to anticipate that that would be sufficient to comply with the law.
Well, the economic impact statement did say those things that you've cited. Didn't go into the same depth and detail as I'm providing you today.
Mr. Poling, I can only speak for myself, but when we passed this law, we expected that agencies would provide that information in their economic impact statement. And I hope that in the future, your agency will take the time to comply with what I believe the law requires. Thank you very much. Thank you, Madam Chair.
Thank you, Representative. I had a couple questions inside of this, which are not more, I just want some definitions. What are journal clubs?
I believe you're referring to the professional journal clubs. Okay. Am I correct?
Yeah, it's under category 2, continuing education, and there were participating in journal clubs and using self-instructional materials. I just wondered what the journal clubs were and how you measured the self-instructional materials.
So, Madam Chair, what you're referring to, I believe, is in 115.4, definition of category 2. And just for a housekeeping note, I'll note that that is part of the existing regulation, not part of what we're changing, just for information. My understanding is that is generally relating to academic, professional organizations that are involved in academic journal review. And that's maybe an area we could clarify that a little bit more, but that's my understanding.
Okay, thank you. Are there any other questions or comments? Representative Wagner.
Thank you, Madam Chair. What is the point of eliminating the section H on your second or third page, page 3? Why was that eliminated?
As I stand here today, I don't recall the specific reasons we originally decided to delete that. My recollection, vague though it may be, is that that was viewed at some point in the promulgation process, that was viewed to be overly vague. Now that may have been at the AG step, but I'm not sure, and that's something I could follow up on for you more specifically. But my recollection is that at some point in the process, it was determined that that was too broad and general and vague and didn't provide enough guidance.
And if I may, so it has nothing to do with the opioid education you're trying to do. It was just some cleanup measure that somehow got noted?
That's correct. That's
okay.
Correct.
If you had some information, it just seems real odd that it was dropped, given the intent otherwise.
Yeah, I will certainly look into that. for you, because that, again, my recollection is that was sort of cited as something we needed to clean up.
Are there any other questions or comments? Mr. Polling, I appreciate you for being here, but I would like to see that you add that to your financial impact statement. I think Representative Carmichael had a very good point. So in future meetings, would you please do that?
Sure.
Thank you. Thank you for being here.
No problem.
I think we're done. Thank you so much. Now we have, I believe we have wildlife and parks and tourism. Welcome.
Thank you, Madam Chair. Members of the committee, I am Chris Tymason, Chief Counsel for the Kansas Department of Wildlife, Parks, and Tourism. And I think we've got two sets of regulations before you today. If you'd like me to begin.
Yes, please. Thank you.
So I think the first regulation that you have is KAR 115-1-1, its definitions. We're striking some language related to possession of permits, and it's in reference to, as we move towards electronic licensing. For example, I have my son's deer tag also on my phone as well as mine, so technically it would be unlawful, and that's what we're changing.
So we could call the Wildlife and Parks Police and make sure that you're sufficiently warned.
Correct.
Okay.
Like me to continue?
Yes, please. Unless there's a question about that. Anyone else want to get them in trouble? No? Okay.
All right, 115-4-6, deer management units. We're making a correction to a boundary that was, we made an adjustment in Unit 19 2 years ago, and as we were working those boundaries out for the map, we realized we left about a mile off of one of the maps, so it's not a real huge impact, but, and then there are some updates to nomenclatures of roads that currently exist as boundaries.
Okay. Any questions or comments? That's two strikes now, I guess, so.
All right, the
May
next
continue.
regulation is 115-25-9, deer open season, bag limits and permits. We are updating the regulation to allow under 17 and under to be part of the youth season. Currently it's 16 and under. I think that as we're standardizing our regulations more and more every year, there is concern that we're not getting enough youth participation, and we want to ensure that we're not competing with those other activities, giving kids maximum time to come and hunt. And so you'll see those changes in the future in all of our other regulations that we have youth seasons. We're going to go to 17 and under. Also, we're just updating for the deer season, the season dates. Those are the only changes in that regulation. Same season structure, just calendar for this year.
Questions or any comments? Seeing none? Oh, it's Representative Wagner.
Thank you, Madam Chair. Actually, going back to the very first one about the individual licenses, I would presume the reason it was originally banned that you can't carry somebody else's license is because you might try and like pass it off as your own or something, or is that? But so you're basically thinking that's not a big issue, or it's just unavoidable with electronic devices, or what?
So I've been with the agency 21 years, and my background is law enforcement as well, my undergraduate. People will violate the law. A certain percentage of the public will violate the law, no matter what. And merely making something which is otherwise unlawful to possess. It's not like it's cocaine that you can't lawfully possess. I think that that's a bad approach to law enforcement, but I think there still will be some fraud. You still have to catch that individual in the act, and them using somebody else's permit to tag a deer is still going to be unlawful. This is just decriminalizing that possession portion of it.
So there will no longer be any paper copies of deer permits, and all be like on a cell phone? Or,
No, we still have paper copies. So people, like you could walk into our office and buy a green, they're like a little green tag. That's your deer tag. And when you tag your deer, you put that onto the rear hock of the animal. When you have an e-tag, you take a picture and you upload it to our tagging system, and that validates it, and it gives you a confirmation number that you carry then with you.
Senator Warren.
Thank you, Madam Chair, and thank you for coming today to testify. Currently, if you're carrying another individual's license, does that other individual have to be a minor, or would this apply? I guess it would be anyone, not just your own child, but anybody else you would have on your phone.
If you had your spouse or your hunting partner, you could certainly have, you have to log out and then log back into a system. It's not like I would have access to that if I didn't know their entry information, you know, the KDW PT number and then their password, so.
And this would not eliminate paper copies?
No, we just have
license.
tried to accommodate today's society. You know, my children, for example, do their homework and stuff online. Everything is online for them. And so it's a foreign concept for my son to think that he has to go somewhere to get a paper tag and then come and tag a deer when he could just do it on his phone.
I hear you. In our family, we have the same thing. My kids are online for school, and they also have hunting licenses too. So if I may, Madam Chair, one last question. Thank you. We've seen some recent problems with electronic filing in other departments in the state. So do we have a two-step authentication or something to make sure that this system operates with security and integrity?
So all of our system is developed through a licensed vendor, and they have to have the same security settings and systems as banks, for example, because of the information that they carry with credit cards when somebody buys something online. You know, there's a pretty stringent standard. For me to log in on my phone, it doesn't require 2 steps. It's something I think we can think about, but we're in infancy stage. We started this last year. This is the first year of e-tagging. So to answer your question, I don't think there's I did not use it this year. I actually bought my paper copy for whatever reason. I just am in the habit of doing that. But I'll take that back to our folks for something to think about. The e-tag system is not connected to the licensing system, even though it's the same vendor who develops it. You can't access all that other back information. I don't know that there is a high desire to find out when somebody tagged a deer, but certainly security is something we always take serious.
Sure, and I think it's on the mind of a lot of Kansans these days with other issues we're seeing in other departments. So while it's in its infancy, maybe we can then plan and have something in place that as this goes forward and it becomes more popular to get the e-tags. I think my husband gets the paper licenses and the paper tags as well, that we keep it secure as Kansans would expect. Thank you. Thank you, Madam Chair.
All right, is there any other question or comment? There was one for me. It has to do with deer season. I noticed there were bag limits for the other animals. When do you set those limits for deer? And is that in a completely different statute, if I remember correctly?
It's in, I'm sorry, it's in this regulation that we just talked about. So it's 1 per carcass tag, essentially, and then if you look in that regulation, it adjusts harvest by management unit based on scientific data. So we do a bunch of surveys, we get a bunch of information, we look at deer vehicle accidents, all the things that go into management of deer. And then we authorize, if I walked in and bought a deer permit today, I would be able to buy an over-the-counter deer permit that would allow me to harvest 1 buck or doe.
Okay.
And then I could harvest another doe statewide. And then depending on the unit, it would either be 0, 1, or 4, depending on what we think the population's doing. If the population's increasing, we're gonna allow 4. If we think it's decreasing, we're gonna allow 1, fairly stable, or we may have to go to 0, like in the far southwest, in Unit 18, which is like Morton County area.
Thank you very much.
I've got some more regulations.
Yep.
There
What's next?
are, all right, 115-3-2, rabbits, hares, squirrels, legal equipment taking methods and possession. We started looking at our small game regs and trying to standardize a few things related to small game. And so if you look down, we standardized the running and box trapping seasons for hares and rabbits. That's it.
Are there any other questions or Representative Wagner?
I'm a city kid. What is the difference between a hare and a rabbit? Are they
Right,
not-
so there's a cottontail rabbit, and then there's a or I can't remember the hare, but body size is different, their shape is different. So it's like they call them jackrabbits, right? A jackrabbit is a hare, essentially, which is different than a cottontail.
Perhaps you could bring a sample of each for Representative Wagner to see.
I'll take a look and see if we have something for next time.
I would ask you to get back to us about verification, your verification system for Senator Warren.
Sure,
Please.
I'll do that. I've still got
Yes.
4 quick ones, I think.
And I still have questions regarding hares and jacks.
115-9.
Seriously, I
Just say
do,
who
Madam
does.
Chair. I'd like to be
Yes.
recognized.
Representative Carmichael, go ahead.
Thank you, Madam Chair. Mr. Thomason, I note that these regulations prohibit taking rabbits by light amplification devices or devices that cast light upon the game. And so I assume when we talk about light amplification devices, we're probably talking about nods. And when we're talking about placing light on the game, we may be even talking about laser sights. I'm not real sure because I've never hunted rabbit with anything other than my own 2 eyes, so I'm not familiar with these new techniques. But why is it okay to hunt coyotes at night with nods, but it's not okay for us to go rabbit hunting at night with nods?
Sure, I assume that goes towards your bill.
As a matter of fact, it does. Yeah, I think you'll be hearing more about that as time goes on.
So if, for the committee's benefit, we authorize the use of night vision equipment, spotlights, and thermal imaging equipment to hunt coyotes from January 1st to March 31st. And there are some parameters on that. You can't shoot from a vehicle, which you can do for coyotes during the day. Not on public land because of the multiple uses. And off the top, I can't remember, I think there's one other restriction. Coyotes are often maligned in our state. We have year-round hunting seasons. We also have concerns with balancing harvest with farmers and ranchers, and concerns about during the calving season, which is why we authorize that use of those devices at night from January 1st to March 31st. So from an ethical standpoint, there are those who think the use of spotlights is unethical and therefore it's become unlawful in certain circumstances, like deer. We don't allow to be spotlight at night. Rabbits, as Representative Carmichael brings up, and I think most every other game animal that we have, we don't allow the use of spotlights. There are some exceptions. Fur bears, you can have a headlamp or a flashlight while you hunt them at night if you're running them on a trap line or with a dog. So to his point, I think that some people think that it's unethical to use light to kill small game animals. And some people, a lot of people, don't think it is unethical on the coyote side.
Madam Chair, just one follow-up question. Of course, recognizing that irrespective of hunters' ethics, some of us are concerned that somebody's going to get killed when we go hunting coyotes, particularly now in urbanizing areas with night observation devices. But my real question for you, Mr. Thomason, is it during these time periods and under these conditions, it looks like it won't be legal to hunt rabbits with night observation devices. But is it now legal in Kansas during the right times and at the right places to hunt coyotes with the same types of devices that are used by our troops in war that allow for amplification of light at night, otherwise known as nods?
Yes, I think that that's a fair assessment. When I was in the infantry in Iraq, I used night vision equipment. And I don't think it's probably the same equipment. It certainly allows an opportunity, and we didn't use thermal imaging in the Army, and we also didn't use spotlights. But you can also hunt coyotes at night without the aid of artificial light the rest of the year.
Well, and I was well aware, of course, of your distinguished service, which I greatly appreciate. I just don't think it's a good idea to have bullets flying around at night, whether you're shooting coyotes or rabbits or virtually anything else. Thank you, Madam Chair.
Thank you, Representative. Is there anything else? Now you have the geese, correct? Is that the last?
Vehicles.
Vehicles, and then go to geese.
115-9-6, vehicle permits and display. It's allowing permits to be essentially, as we've moved more towards electronic, as you come in the gate of a state park now, hopefully soon we will have electronic kiosks, and there will be nobody there to tape that to your window, so it allows you to place that electronic receipt onto your dash rather than have somebody tape it on.
Okay, are there any questions or comments? Then you may proceed.
115-18-13, it dealt with dark geese. We're revoking the regulation. It hasn't been in use since 2006, I think. Currently, it used to set boundaries for a couple small units when we had geese populations that were low, and we have not used that for many years. So we're revoking it. 115-25-2, rabbit open season bag limit possession limit. We're standardizing the possession limit at 4 daily bag limits, the same as pheasants, trying to standardize some of those regulations. And one more, 115-25-3, hares open season bag limit possession limit. We're doing the same thing, standardizing that at 4 daily bag limits for the possession limit.
All right.
I believe that's it. If you have any more questions.
Representative Wagner.
So are these dark geese, are they on the dark web, or is that, am I mistaken in that?
Oh, that hurt. That really hurt.
I will comment on dark geese if you want, but not on that particular.
What exactly is a dark geese? I mean, it's...
So a dark goose is, so we have snow geese, just generally snow geese, which include Ross's geese and blues and snows. And then we have dark geese, which are Canada geese and brant. And so the majority of those are Canada geese in our state. Brant are more of a coastal bird. But those are also, all of our waterfowl stuff regs are set in federal regulation. We transmit to the federal government. They post in the Federal Register, and that becomes the law of the land. So we really didn't need this regulation anymore.
Did you get your question answered? Okay. Is there anything else? Not, thank you very much for being here. We appreciate it, and I'll look forward to getting some of your information.
Sure, thank you.
Okay. Thank you. All right, next up, we have the Kansas State Board of Technical Professions. Welcome.
I'm not sure if it's good morning or good afternoon. I'm Larry Carnes. Thank you for the opportunity to allow me to get out and brave the February heat today to come see you. Anyway, Kansas Board of Technical Professions has one regulation pending. Under KSA 747013, the board is to adopt rules and regulations describing minimum standards for boundary surveys. This is legal descriptions and meets and bounds descriptions of land. We regulate and license land surveyors in the state of Kansas. And there is a Kansas State Society of Land Surveyors. They have developed minimum standards for the practice of land surveying in Kansas, and we are adopting, this regulation would adopt those regulations by reference. I can't speak specifically to the requirements of the minimum standards. I'm not a land surveyor. I did bring a member of my board who is a licensed land surveyor, Mr. Haverkamp, who would be happy to respond if you have specific questions about these minimum qualifications.
Are there any questions or comments? Anyone online? Thank you for bringing that. Oh, Senator Warren, sorry.
Thank you, Madam Chair. Could you explain just real briefly again, we already do have minimum standards in Kansas currently, correct?
We do. My understanding is the surveyors basically are updating their standards from, they had standards adopted in the past.
It looks like they were operating under standards that were last amended December 2009, and then this proposed regulation would bring it up to date by using the minimum standards that were put in place on November 21, 2020. Do I have that right?
You do.
Great. I think it's good to be up to date and on the standards that we require for this very important profession. I appreciate the work that they do in the area that they work in. Thanks very much for appearing today. Thank you,
all.
Madam Chair.
Thank you.
Representative Wagner has a question.
Sir.
It had struck me before, and it goes back to an earlier question one of the other representatives mentioned about in Section H, about the notification requirements for other people. It just seemed to me that you folks just sort of did this in-house, that it wasn't really advertised to anybody else. That, I mean, is, you know, again, if it's just an update, maybe that's standard procedure, but I am kind of curious about what the appropriate, or what the, you know, under Section H, if that.
I'll speak to that as best I can. This was a process that was in place before I came to the board about 1.5 years ago. They'd been working on this for 2 or 3 years, actually. And they had had different gyrations or versions, if you will, of the updates. They went back and forth. The land surveyors meet annually. They review these. They had a committee of those folks that reviewed them. This is for those practitioners. So primarily it was something that they needed to do internally.
Okay, are there any other questions or comments? The only question I have is you probably would know the answer to this. We're still doing minutes and seconds and legal descriptions. Do you have any, are there any changes with that? That was a no. Okay, thank you very much. He said no. And thank you for being here.
Appreciate it. Thank you all.
All right.
Madam Chair, I might observe real quickly that the reason we put minutes and seconds into legal descriptions is so that lawyers and land surveyors can charge more for interpreting those minutes and seconds and converting them to decimals. Thank you.
Thank you for that insight, Representative. I just know that we have to type a lot of that in my title business.
I absolutely agree.
All right. Are there any other questions or comments?
I do. Oh.
Or Senator Warren, sorry.
Thank you, Madam Chair. And I think actually, like the gentleman answered, you couldn't really hear because it wasn't in a microphone, but it's related to minutes and seconds of the angles of degree when you're describing the boundary of a piece of property. And so I think that's what the answer was. So not to be difficult in how you write legal descriptions or anything, but the angles are important as you're describing, you know, turn left, turn right, certain minutes and degrees. So it is difficult though, if you're not used to that.
But you don't go left or right in legal descriptions. You go north, south, east, or
That's
west.
right, a certain amount of minutes and seconds. That's right, and degrees, absolutely.
All right, thank you. All right, is there anything else? Now we have the Real Estate Appraisal Board. I don't see anyone in the building. Is there anyone online?
Good morning.
I think you need to mute your microphone on,
I am. I'm getting.
oh, that's much better. Just one of the microphones needs to be muted. Are you still with us? We could hear you before with a little bit of feedback. So if you just turn off one of your microphones, I think we can hear you clearly. We can't hear anything if you're trying to talk to us. I think the problem was you were on WebEx twice. Sally, Miss Pritchard, are you with us?
Hello. I don't know. Good.
The feedback. Perhaps.
Can you hear me? Quit.
I see you on WebEx now. If you can just get on, unmute yourself on the single one you have, that might work better. Are you with us?
Okay, I don't know what to do.
I think, I don't know. Do you have any idea past what you?
Hear me.
Oh, that sounds better.
Starting again.
Speak, probably without feedback. Okay, Ms. Pritchett, would you please try again? Can you by yourself unmute her?
I think I was. All right. Starting again. I apologize.
Perhaps, do you know how to let her just call it in and we can move on and then so people can get back to their. Well, I mean, perhaps we'll just go ahead with the rest of the meeting and then try to come back to you, see if we can get you in.
Are you there?
Yes, we still have a lot of feedback, but maybe you can turn your speaker down a little bit.
I'm trying to. Oh my goodness.
Just, you know, all she has for her change is just to change the years from 1819 to 2021. I mean, it's a real, just totally minimal change, maybe.
Maybe we can just go ahead and talk. Does anyone have any questions about the year change for professional appraisal practice?
I have two different areas of questioning for the board.
We have 3 questions, so if perhaps you can, I don't know if you can do a chat through that without. Representative Carmichael, go ahead with your question. I think she can hear us, but.
Well, with respect, Madam Chair, the agency needs to appear for the hearing. And they can either appear through WebEx and answer our questions, or they can appear in person and answer our questions. But I don't think the committee should get in the business of just mailing it in. And if the person from the board can't figure out how to use WebEx, then we can take up their request at our next meeting. I don't think it would be appropriate for me to just read off the questions and hope that an answer arrives.
Right.
I will comply with your request, of course, if you wish.
It is Pritchett, Miss Pritchett. Perhaps you can come to our next meeting. We're just having a very difficult time hearing you without a lot of feedback, and people will miss it. Okay? Thank you. Let's go ahead and move on. I did send the former letter from Representative Highland that I wanted to just make sure that anyone who was on the committee, if you had any problems with me changing it and sending it back out again, are there any issues with that? Senator Warren.
Thank you, Madam Chair. What are the proposed changes you're going to make to the letter and resend it out?
Mostly letterhead. But
Okay, thank you. That was
that was the biggest
Gonna be-
change.
okay,
Yes,
that's
that's
the
the
change.
biggest change.
okay. If that's the change, I don't have a problem with that.
We also had another discussion on different items, and we talked about perhaps changing the order of when we see these boards so that we have time to get our questions and answers or our changes that we think they should make. And I wanted to open that up for discussion. Because right now we're at the very end of the tail. We are after budget, administration, attorney general, and the secretary of state. And most of the time our meetings have to be held in a short period of time because we get right up to the end of the regulations they want to change. So I wanted to open it up for discussion as to when we get it. Representative Wagner.
You know, having never been on a committee like this, what would be the alternatives? I mean, we would have it, if we don't have it at the end of the process, which is, I guess, where we are right now, how would they change it, or what's the options?
I think, there are revisers. It's not in statute, is it?
Madam Chair, this is Jenna Moyer with the Office of Revisor Statutes. Can you just say your question again? I want to make sure.
About changing the order of when we get these regulations.
Mm-hmm. Yes, so it currently is in statute that the review by the Joint Committee is during the public comment process. And the public comment process follows approval by the Division of Budget Administration, AG, and the Secretary of State. And I believe the issue that the chair is referring to is just related to the scheduling of this meeting during that 90-day public comment period. Depending on when the committee meets, it can bump right up against the actual hearing with the members of the public. And so there's less opportunity for the comments or feedback from the joint committee to be brought forward to the actual public hearing.
Okay. We can think about it and then perhaps discuss it at the next meeting. I just felt like we get pushed into a corner a little bit with some of these deadlines, and thought it might just be a little more efficient to get to them sooner and put our comments in before that.
Madam Chair, a suggestion?
Yes, Representative Carmichael.
Thank you. I don't know all of the details of this, but what puts this committee in the crack where we can't really prepare and do our job is that we don't have an internal rule that says if you don't request a hearing with us or you don't provide us with your testimony, your financial impact statement by some date certain in advance of our meeting, that we just won't hear it. And we could even probably establish a committee rule separate and apart from what's in the statute, so long as it's not in conflict, that says if you don't have these materials to the committee at least a week in advance of a hearing date, that your regulation isn't heard and you can wait till the next time around. Because I feel like the problem is getting these at the last minute. I honestly don't want to see every revision that goes back and forth between Department of Administration and the agency, or between the Attorney General and the agency, because honestly, I don't have time to read all of those preliminary drafts. So just as we're thinking about that, we might give a little consideration to finding a way to force agencies to give us timely notice. And the final thing is that there have been times that we have had to meet at the very last minute because an agency had a public hearing scheduled and so on. And so we end up meeting the day before, or 2 days before. And I find it hard to believe that our preliminary reports are getting any attention from those agencies. So I appreciate you hearing my thoughts, and we can keep working on this. Thank you.
Thank you, Representative. Does anyone have any thoughts or comments or that they wanted to add?
Madam Chair,
Well,
my
I
hand up.
think-
Oh, hold on a minute. That might help.
Is that Representative Keither?
Yes, it is.
Okay, I'm recognizing you. Go ahead.
Okay, thank you. Thank you. I think Representative Carmichael makes some very fine points, and I also want to thank you for bringing this to our attention, to the committee's attention, that we might be able to do a little bit better job of addressing these issues. But I certainly think that Representative Carmichael made some great suggestions, and just wanted to let you know I support that. Thank you.
Thank you, Representative. Is there anything else? Representative Wagner.
So with these hearings that we have here, so then what do we vote to approve something, there are changes, or we're just here to give input, or what is the gist of this committee?
Perhaps the revisor could do a short update on
Yes.
why we can't do that. Thank
Madam
you.
Chair, this is Jenna Moyer in the Office of Revisor Statutes. And the general outline of the process is the legislature gives authority to pass or adopt rules and regulations. The agency draws them up. There's a back and forth period with the executive branch agencies getting their approval, Department of Administration, AG's office. And then there's a public comment period. And I was incorrect. I said 90 days. It's actually 60 days pursuant to what is it, 77 KSA 77421. And during that public comment period, the agency is not required to come before this committee. However, the committee is required to hear the agency, which is kind of a strange little iteration of that law. And so there is no formal approval required from this committee. However, the Joint Committee does, in their review process, if you were to find that an agency had overstepped its bounds, you could introduce legislation to cut back that administrative rule and regulations authority. And so that the general process is the agency comes before the committee gives feedback. Oftentimes, the agency takes that feedback or not, and then the public hearing proceeds. I hope that answers your question. If not, I can follow up further.
Thank you very much. That did it for you, yeah, for right now? Yes.
Thank you, Madam Chair. So it would seem that is a key gap if based on the discussion we had, what, a month ago, I can't even remember when we met.
Yes.
If there is the desire to, for lack of a better word, add to the authority or add to the statute of this committee, then if there's no requirement in the law, I don't think it would be logical to proceed without at least addressing that. I'm not suggesting what to do about it, but at least we need to find out what our options are.
Yes. Thank you, Representative Wynn. Part of it is trying to change how we do legislation. And that was what Chairman Highland had sent out in his letter. So that's why I wanted to send that out again. And I think before the next session, the chair would be Senator Warren, and she might be able to send something out to all the.
Well, question is, does this address enough at this point? I mean, is there anything you would want to add?
I know that we are somewhat hogtied by a lawsuit that was, and I see my committee assistant shaking his head. Would the revisor comment on that shortly?
Yes, Madam Chair. I'm Jenna Moyer, Office of Revisor Statutes. There was a lawsuit in I believe it was 70s, Stephan v. Representative Carmichael's going to correct me on this name because I say it in the backwards order every time.
It's just House of Representatives.
House of
Stephan v.
Representatives.
Kansas House
Yeah.
of Representatives.
And the general standing of that case happened after the legislature passed authority to essentially veto regulations through a concurrent resolution that did not require a signature by the governor. And the general proposition we take from that case is that the legislature cannot, after they've given away the administrative rules and regs authority, you cannot come back and say, we don't like agency, how you did these rules and regs. And so the opportunities to approve or disapprove regulations in general are quite limited for the committee, which is why the committee has the power of legislation to go back and curtail that rules and regs authority. Oh, and Madam Chair, I should also note there is LCC rule policy 33, which prevents an individual committee for speaking on behalf of the entire legislature. And so the power for the legislature is in either the 40 or the 125, not in the individual committees to speak on behalf of the entire legislature.
How does that differ from other committees now? I mean, it's not the committees themselves are making final decisions. It goes through a process. So how is that different?
It's different because this committee doesn't hear necessarily bills. I mean, a regular committee, it gets either passed by the House or by the Senate, but the actions of this committee would not be subject to review either, on GO in the House or the Senate. And so if this committee were to say, we don't approve of this regulation, there would be no check from the legislature as a whole to whether or not you approved or disapproved. So if there were rogue committee members who happen to really hate one agency, happen to all get together on the joint committee at the same time, they could act in a way that the legislature might disapprove of.
Great. Thank you very much. Are there any other questions or comments? If not, I'll make sure I get this letter on the way shortly. We're about done, but at least we can start. Also, I wanted to add that thank you very much. Jill Shelley got a list of what bills are out that have this language in it, getting rules and regs, giving them the right to do rules and regs with no oversight. So we'll look at that. We'll look at that as well. I'll send that through our committee assistant, if that's okay with you. All right. Yes, Senator Warren.
Thank you, Madam Chair. Just a point of clarification on the letter that you're intending to send. The sample we have says it's addressed to chairpersons. Who is the intended recipient of the letter?
Chairpersons of each committee.
Of each legislative committee?
Mm-hmm.
Okay. Thank you. I didn't know if it
Both
was,
sides.
I didn't know, so I just
That's
wanted
right.
to be clear.
That's
Thank
good.
you.
Thank you. Anything else? Anyone who's here, we do have some lunches and some water, so please help yourself. Thank you for going through the lunch hour with us, and we'll see you again. Thank you,
Chair?
everyone.
Madam Chair,
Oh,
I
I'm
hate,
sorry.
I hate to interrupt.
Representative Carmichael.
Thank you. I was asking for recognition regarding the letter. There was discussion at the time the original letter was prepared of perhaps having the vice chair and chair sign on to the letter and sending it to committee chairs in both houses. Because as you know, our chairpersonship rotates from the House to the Senate. There was even a suggestion to put the ranking minority member's name on there, but I don't think that's necessary. But you all might consider letting the vice chair give some thought to whether that would be a good idea vis-a-vis our colleagues in the Senate. Thank you.
All right, very good idea. And if the ranking minority member would like to be a signatory on it, I'm more than happy.
No, I think my signature would actually aggravate the situation, not improve the situation for reasons that we all know.
Never, never.
And Madam
All
Chair,
right.
if I could,
Yes. Thank
if
you,
I may,
Jen.
we usually do a review of the comments that we've made during the meeting, and Jill just messaged the group asking for that. That way it makes our lives a little easier, clarifying the comments that should actually go out in the report.
Jill, did you want to speak to that?
Oh, Madam Chair, sorry.
Yes.
Usually just the committee goes back through the regulations and just clarifies, hey, these are the comments we would like to
Okay.
see in the final report.
Okay. Yes, Senator Warren.
Thank you, Madam Chair. For those who were on the committee prior to this session when the letter from Representative Island went out, was it a discussion on the committee as a whole that adopted, on the committee?
This
The
committee
joint
as a
committee,
whole,
yes, this joint committee that created the content. Was there discussion and it was agreed to? And kind of what was the process, if someone on the committee from last session could address that? Thank you.
Yes, it was discussed in meetings and with all the committee members there. And I think you all, remember that as well, correct? So there was vetted by everyone that was on the committee at that time.
Thank you.
All right, let's go through. We've got regulations for hearing. Department of Agriculture, Division of Conservation. Did anyone have a comment that they wanted to send to the Conservation Division? All right, the next one was the State Board of Healing Arts. Does anyone have for KAR 100-15-4? Continuing ed requirements? No hands up, we'll move on. Any comments on Wildlife Parks and Tourism Commission? See someone shaking his head. So that says you're not going to say anything other than the Representative Carmichael.
I
Do you
made
wanna
some
make-
comments during the hearing, but I don't think they need to be, they rise to the dignity of being formal comments of the committee.
All right. Well, thank you. Okay, now we'll move on to State Board of Technical Professions. Any comments that you wanted to add? Don't see anyone. And we did not hear the Real Estate Appraisal Board. So I don't think we have any. All right, thank you very much for pointing that out. I appreciate it. If that's all we have, then I would call this meeting adjourned. Thank you, everyone, for being here.
Madam Chair,
Yes.
if I may say that the hearing for the Real Estate Appraisal Board is on April 19th. So we have to take that into consideration for scheduling the next meeting.
I'm sorry, Jill, could you repeat that and so that everyone could hear that clearly? You're a little muffled too.
Oh, sorry. Certainly. The Real Estate Appraisal Board's public hearing is scheduled for April 19th. So as law currently requires, this committee would need to meet before April 19th.
All right. Thank you very much for pointing that out, and we'll try to get something set up that everyone can attend. Senator Warren.
Thank you, Madam Chair. What's the consequence if we're not able to meet before April 19th due to the difficulty that the board had appearing today?
I would ask the revisor to answer that.
In the general problem would be that you'd be in violation of your authorizing, your enabling statute. I mean, in theory, a mandamus, right, could be filed against the committee, but I kind of doubt that that would happen. But that would be the general, you'd just be in violation of your statute. There's no rules or anything about it.
Senator, go ahead.
Thank you, Madam Chair, and thank you for the response, Jenna. Does that mean that the proposed rules and regs from the Real Estate Appraisal Board would go into effect?
Madam Chair, that would be my presumption, is that without this committee's hearing it, if you are unable to schedule the meeting, they would presumably go into effect, given the caveat that if something came up during the public hearing period that caused grave concern, they could always go back in the process.
Thank you. If I could, Madam Chair, just
Absolutely.
a comment. I think that goes to the concerns and the questions that we heard from Representative Carmichael and Representative Nguyen that, well, we need to hear this, but they're not required to be here and to be heard. And then there's a difficulty with WebEx that isn't the committee's fault. And now we're in this position that we might have a problem if we're not able to meet again in time prior to April 19th. So I don't know how to fix that, but it's an interesting situation, I don't feel through the fault of this committee.
I would say I'd have to agree with you wholeheartedly. Yes, Representative Nguyen.
What is the obstacle setting the next meeting?
I would say there is none. So, I mean, for us to just set another meeting before that date.
Help me understand. Did Jenna say that was what was on the agenda, or that they had to come back?
They're going to come back to our next meeting.
It works when I think.
Well, I think perhaps we need to, yes, Senator Warren.
Thank you. Maybe a question for the revisor. What is the deadline that we need to meet again so we can hear the Real Estate Appraisal Board?
April 19th. So we have from.
Oh, we don't have to meet 30 days in advance of April 19th? Or okay,
No,
that was my question that, all right, if we're, we got to meet 30 days ahead, then we're looking at March something or other. And so,
Yes.
okay. So as long as we meet before April 19th then.
I think
Thank
we
you.
have time to do that.
Thank you.
Does anyone want to look at their calendar now to think of what would be a good time? like another lunch time before we meet again in March.
Madam Chairman, I'm presuming if we pretend that we met in 4 weeks, like at the end of March, that there might be other rules and regulations that will have appeared that would want a hearing as well?
Yes, I would
okay.
imagine, yes.
Okay, I'm thinking that we have enough flexibility with our schedules, with committees not generally meeting in March, that, toward the end of March makes plenty of sense.
All right, and we'll just let that go. All right, and once again, I'm going to adjourn this meeting. Thank you, everyone, for being there. Oh, I'm sorry.
Do you ever have a quorum to get your minutes approved?
We don't.
Okay.
So we're going to save that for the next meeting. We'll have 2 sets of minutes. All right, thank you, everyone. Right by the door. Help yourself. Ally Devine.